Good evening, everybody. Welcome to tonight's planning policy meeting. It is the 25th of August, and I'd like to call this meeting to order at 6:36 p.m. So, is it just me, or are PPC Thursdays the hottest days of the week? I don't know how we keep ending up here on the 90-plus degree days, but it seems to be happening, so hopefully we can make the most of it. I want to welcome our guests who are here to speak, welcome staff, and also welcome my fabulous colleagues. Each and every one who is so appreciated to be here because of our attendance. So today's meeting is a hybrid meeting. The Planning Policy Commission is in person, but we also have staff here in person as well as virtually. Members of the public may be attending virtually or in person as well. Comments at tonight's meeting may be made in person or virtually. And for all who would like to speak during the public comments, speak clearly and pause frequently. State your name each time before speaking. And if you're attending virtually by computer or by phone and would like to speak during the public comments, in addition to the suggestions above, please mute your microphone when you're not speaking. And if you're having any technical issues, try joining the meeting using a different device, such as a smartphone or a tablet. You can use the call-in information in the meeting invite to call in. All right, Kristen, do we have a quorum tonight?
Yes, we do.
Excellent. Tonight we don't have any meeting minutes to approve, so our first item of business are general public comments for your Planning Policy Commission. This comment period is for general comments on items pertaining to the commission. So please refrain from speaking on the public hearing items for tonight's agenda. Is there anyone in the audience who would like to make brief public comments?
No one has signed up to speak. Tricia, is anyone online?
I do see a virtual attendee who'd like to make comments under the general comment opportunity.
Okay, and excellent. And one thing that I forgot to say last time, but I'll say it real briefly right now, is please limit your comments to 5 minutes or less.
Connie, I'm going to make you a panelist now. Give me just a moment. You should now have the option to unmute and may choose to turn your video on.
Okay, so hi, I'm Connie Marsh. I live up on Squawk, and I'm going to make a comment that I have made so many times in this situation, which is with the depth of the information being provided to Planning Policy Commission, I don't think it is appropriate to have the new information presented, then have a public hearing, and then have deliberation all in the same meeting. One of the issues is a 5-minute public comment period for the public on these topics. You can get nowhere in 5 minutes. So this time I actually had the time to send you 2 very long, in-depth emails. In the last meeting, I had no time to do that. So my public comment was just erased. So I skipped you all and went straight to City Council. I don't think that's how it's supposed to work. I'm one of the last remaining public comment people who does read this stuff and in depth. And I feel cut off, and I feel like your deliberations are cut off because you don't have time to think of varying other issues with the breadth of information that you are being provided. And so I've said this, I don't know, 8 or 10 times before, and I'm hoping that I am the crazy person who says it over and over and actually will get somewhere, though. So there we are. I'm sweating here along with not you in your air-conditioned room, but anyway, bye.
Chair, I don't see anyone else in our virtual public who'd like to make comments at this point. There are a few individuals who have indicated they'd like to speak under the public hearing.
Great, thank you. So we're going to get down to the meat of tonight's agenda, which is the public hearing for Title 18, Bucket 6, general provisions, procedures, and permits. Exciting stuff. So tonight, staff will present the different presentations. Commissioners will ask their clarifying questions, and once all pieces have been presented and all questions asked, we will open up for the public hearing. Lastly, the commission will deliberate on the entire chapter. So staff, Kristen, your presentation, please.
There we go. Good evening. My name is Kristen Leeson. I'm a senior planner with the Community Planning and Development Department. And yes, tonight we're talking about what we're calling Part 2 of Procedures and Administration. So I will be sharing the first part with you, and then followed by Valerie Porter and then Minnie Dhaliwal. So there are 5 pieces to this: legislative updates, major updates, levels of review, public projects, and vesting that we will be talking about tonight. First, legislative updates. So we're going to start with the rezone process and what is new there. So we have differentiated between quasi-judicial and legislative rezones, and rezones that require comprehensive plan amendments and those that do not. And I'm going to take a step back. Some of you may recall that over the past 2 or 3 years, we have had difficulties and some uncertainties regarding the comprehensive plan docket and rezones, and what the process was, what some of the criteria were to approve or not approve. So our whole purpose of this legislative updates, and you'll see it in every one of these, is to provide clarity in this. So I'm going to sound repetitive, and I am repetitive, but that's why we've done it. So as I mentioned, we differentiated between quasi-judicial, which I can't say, and legislative rezones, and the process for those for clarity. And we've also expanded the explanation of processes for rezone requests for clarity. For the comprehensive plan updates, we added a comprehensive plan docket criteria for decision, which did not exist, and that was one of our issues prior to this. Again, clarity. We clarified docket approval process and how that went, because the steps for that was not clear. We included exceptions to annual amendments, because what the state says is that you can amend your comprehensive plan once a year. And the state also provides exceptions, but those were not in our code. So for transparency, we thought we would throw those in case for some reason we had to do a second amendment that year. We wanted everybody to easily find out how we were able to do that. And lastly, in land use code amendments, we expanded the application and approval process, because I think the whole thing contained 4 lines. And so we expanded that for clarity, and we also added approval criteria, which did not exist before. So that helps the council and the PPC when they make recommendations, staff when they make recommendations, and council when they make final decisions. So that's all I have for legislative. You all have any questions?
Are we going to go through the whole presentation first and then do all of it?
You want to go through the whole thing first?
Sure.
Okay, all right. So next up is Valerie.
No, I
Yeah,
apologize. That was your entire...
That's my entire presentation.
Wow.
I know. You want me to present every time.
For how thick that packet is, that is amazing. How efficient. All right, let's open up Commissioner Milligan.
I'll ask a question just to warm people up a little bit. It's not a very good question, but when we were talking about what we could include on the docket, and there was individual property request for rezone, and can you just remind me how we avoid spot zoning when a party comes forward with that kind of request, or you know what I'm talking about? Am I saying that right?
You are, and so this has come up before in the past, and that one's, it's not difficult because a spot zone is illegal. So what we have said in the past is that we will continue this through the process, because that's what you've asked us to do, and the city council can deny it. And that's what we did, and we explained too, when this came through before, that spot zones are illegal. So if they were to approve it, there would be consequences, so, yes.
So then what is the justification for even allowing that and having it as one of the items that we allow on our docket?
In the past, I've always been told that the public, and it's true, the public has the right to be heard. So they can take it through and the council has the option to deny. Yeah.
I had a question about the application procedures. I'm on page 68 of 110 for anyone who's following your packet. And we talk about how a city initiated some agenda item. I'm curious if there's a detailed plan for other boards and commissions besides PPC. Staff is always great at giving us the opportunity to do that, but our code right now is written to allow for all of our boards and commissions to be able to follow this. But I don't see a plan or place of how we're planning on letting them know how they can do that, when they can do that, and present that.
Usually boards and commissions don't initiate it, it's initiated by staff, and there is a place that staff can initiate it. So staff liaisons, if it's come up through a board that they wanted to do that, the staff would talk to us.
Is there any discussions about how to better inform the boards and commissions about how they can work with staff to then maybe put something on?
Not in here, but we could talk with staff liaisons and share that with them.
Okay, thanks.
Any other questions for Kristen? All right, well, thank you, Kristen.
You're welcome. It's Valerie is up next,
Valerie's on, yep.
and she is, yeah.
Hello, my name is Valerie Porter, Associate Planner with CPD. Like Kristen said, I'm going to be talking about major updates. Next slide. All right, so I'm going to briefly go over some of the changes, mainly because many of the topics have already been brought to PPC as policy questions. And so a lot of the changes that that you see in this chapter are changes that reflect this direction that we've received. So the first topic that we're going to discuss is definitions. And definitions. So all of the definitions from the Central Issaquah Development Design Standards, the Design Manual, the Old Town Design, standards, all of these definitions that were in all these different chapters have been consolidated and placed in one chapter. We also made some additional changes to the definitions, like we tried to make them clearer. If they had some standards, we removed those standards from the definitions. And then we also tried to reference state code when possible, just to try to simplify the code. Another change that we made in this chapter is that we tried to consolidate meetings. We have 3 kind of like neighborhood meetings that all kind of serve the same purpose. So we have the neighborhood meeting, the environmental neighborhood meeting, and the community conference. So we removed that, and now we just have one prior or post meeting. Another change is the administrative adjustment or standards section. So previously we just kind of outlined what topics were prohibited from receiving an administrative adjustment and standards. Now we clearly specify exactly what you can get an AAS for. In each chapter going forward, you're going to see specific approval criteria. You probably didn't see it in the first round, but now we're going to go back and add specific criteria in the next chapters. We also try to kind of simplify the levels of review. So one of the changes is that we've eliminated the administrative site development permit with no public comment. So we went from 6 levels to 5 levels. And then we also reversed the level 3 and level 4. So just as an example, a site development permit today is a level 3, but in the new code, it's going to be a level 4, but still going to be reviewed by the Development Commission. Next slide. So we also added the technical document review section, which basically no longer allows the decision maker to review and approve technical documents. So again, as an example, the Development Commission will no longer, review and approve a traffic study or a critical area report that will be approved prior to the project coming to the decision maker. We also changed the public notification section. We've increased the notification radius from 300 feet to 500 feet. And we've also are allowing notifications to be sent to property owners as well as renters. And then just in general, we tried to simplify and clarify the code. So in certain sections, we either removed and or relocated sections. So for example, we had a boards and commission section where it kind of outlined uh, the task and responsibility of each, board and commission. We actually relocated that section to Title 2 because we felt that that was better suited. We also tried to, just simplify the code and replace text with tables to make things a little bit more clear. And then we also added sections like application withdrawal or reconsideration, which allows the decision maker to reevaluate a decision if there's any errors in the application. And we did this to try to make the code a little bit more clear and also just improve the process. And those are most of the changes. Are there any questions?
Thank you, Valerie. Any questions for Valerie?
Hey, Valerie, we miss seeing you, but we're glad you're here with us because this is a big section. I'm going to start with a big meatball because I'm a little confused about how we've been consolidating the community meetings. I'm looking right here at our goal and outcome of improvement and development, not consolidation, right? So what I'm actually seeing is a little bit different from what our goal was. And when I was reviewing the RCW, what I found was guidance about what happens when a developer wants to consolidate their community meetings. Our code right now looks to me like it only discusses that option. What happens when a developer decides to consolidate their permits, and so we're doing it all in one, as the RCW dictates. What I don't see is any language in our code that talks about when that doesn't happen. We would then have more community meetings. We would then actually need to have kind of another section that says when a developer does not consolidate, but I feel like I might be reading that wrong. Is that, did we decide to only go with the RCW talks about if a developer consolidates, so we put our code to only being applicable to a consolidated format?
That is a big meatball. So I guess I don't know if so the pre-application meetings are something that the community or the administration has decided to do. I don't think they're dictated by the RCW, but the reason why we've consolidated them is because a lot of them serve the same purpose. And we've also received direction from our council that how one of the meetings was set up, it wasn't in our best interest, which is why one of the community conference was eliminated. The neighborhood meeting neighborhood meeting and the environmental meeting are essentially the same meeting. I think the only difference is that one just focuses on environment, critical areas on or adjacent to the site. And so it just really made sense to not kind of overcomplicate the process and just to try to streamline it, because how we are doing it right now, if a project wants to move forward, we would have a neighborhood meeting / community conference on the same day and try to, have all of the different groups together. And it kind of, at this moment, it's kind of complicating the process. And then I think also we've heard from the community members that they feel like they're not actually getting that opportunity to have that open dialogue with the developer. So like, for instance, the neighborhood meetings are supposed to be more informal, and so that the community can speak directly to the developer and say, what they like, what they don't like, or things that are happening in their neighborhood, but they're not really able to get that with all the meetings. And so we just tried to reformat it so that that could occur. But sorry, I can't really speak to the consolidation part from
Minnie's raising her hand in chambers.
But she can probably
Tag.
in terms of the consolidation that you're talking about, so that's the state law for, instead of having a series of public hearings, you are, it's part of the streamlining under the state law that happened many years ago. Applicants have the option to request be consolidated to the higher level of review. For example, if a project triggers a variance application, which would be under the proposed draft a level 3, and then they also had a development commission approval for something, for the project, which would be a level 4, they can consolidate that into a level 4 at the applicant's discretion. So we will have language if it's not in the current draft. So that's what the state law requirements are for consolidation of public hearings. So the idea there is that if someone wants to appeal, it gets consolidated into one appeal and one public hearing. So it doesn't drag out the process with multiple public hearings.
So am I reading this correct, that we formatted our code to align to that without there being a separate section that says?
I think
if
it
If you
exists,
don't
yeah.
consolidate, then this is the path.
I think that what you're talking about is the it's not the it's not the decision, it's not the tail end, it's
Right.
the actual early input happened in different formats. We called it different things, it added to confusion. If there were 2 types of meetings triggered, it didn't make sense for the community members to come to 2 different meetings, so that's the part of the earlier community feedback meeting is called one community meeting instead of 4 different flavors of meetings.
But right now,
Mm-hmm.
am I reading it correct that we have it written as one, regardless
We
of?
have, for the early meeting, it's
Yes.
called pre-application community meeting in the proposed draft.
Okay, thank you, that's what I was trying to see if I was reading that right.
Yeah.
Who wants to follow up that question? Commissioner Milligan.
I have a related question, so.
Okay.
Yeah, hi, this is, I guess I don't need to introduce myself anymore, you can read who I am. But I had a, kind of a question building on that, because when I read about the meeting consolidation, the question that came up is, does that like eliminate voices? And I think what I hear you say is that it's actually like public feedback saying like, I don't want to attend 4 different meetings. I'd rather attend one and have that more open dialogue. And so this is actually solving, not just making it easier for the developer and staff to kind of only attend one, but also there's a community kind of engagement.
Sure, so under the existing, code, we've had where an environmental neighborhood meeting is triggered and a collaboration meeting, I don't know if I'm getting the names right, but, so one is chaired by the Development Commission, the other one is staffed by the staff. And it created a logistical nightmare to kind of do them, on separate nights. Didn't make sense for the community members to have to spend 2 nights to talk about the same project. So we structured it where it was just open dialogue without the Development Commission, but they couldn't hear that because they were only part of this, other things. So that added another logistical challenge. So yes, it's the way we currently have different types of meetings is challenging to implement for staff and for the community members to understand the differences.
First of all, I want to ask if this is the place where we ask the question. In our packet, we are talking about, you have a question to us about the thresholds for level review. Is this the chapter or is that later?
We have policy questions following Valerie's
But is this the
presentation.
section in our
Yes.
presentation that I
No,
can ask a
it'll
clarifying
follow.
question?
It'll follow Valerie's.
Okay,
It'll come up.
I'll ask later then. Thank you.
Any further questions regarding Valerie's presentation?
I have one for Valerie about adjustment of standards. Something we had talked about early on in this process was having a little more daylight into how these adjustments happen and effectively creating a checklist, right, for there to be a consistency across projects for both community awareness and for developers to be able to understand. I didn't see that. Is that something that's still in process, or is that something that we decided to drop off? Because it's not really mentioned right now in any of the language.
Yeah, so basically in this section, we're just referencing the specific sections that have these AASs. Instead, we're going to go back into all those sections and create approval criteria that makes it very clear about, when you can get a deviation and what that criteria needs to be so that we can apply it consistently. So it's
that-
still in the works.
Thank you.
The list is in the draft, right? So the things that people can apply for a specific deviation that allows administrative flexibility is in your draft. The criteria for that list will be in individual chapters.
And that we will see next.
Correct. So the existing code has, you can't apply for these 5 things as administrative deviations, but everything else can be applied for with this very broad criteria. So that's eliminated. Instead, you have specific things that you can ask for, but the criteria for those specific things you'll see in the consolidated draft.
Okay, thank you.
Any further questions for Valerie's presentation? Hearing none. Thank you, Valerie. And Minnie, I believe you're up.
Yes, so let me share the screen again. It's not- So you can see. So the next one is the level of review. So we posed a policy question to all of you. What's the size of the building that should be reviewed administratively as opposed to by the Development Commission? So level 1 and 2 and versus level 4. The current existing code, so some of these thresholds come from the existing code. So there isn't a magic number with 45,000, but that's what's in our existing code. So we use those as a basis. However, we tried to simplify it because the existing code in Central also has another layer. It says this square feet and or 3 acres or less than 3 acres or more than 3 acres. So in the way we've implemented this code, that really hasn't come into play. If you're actually developing a building, that's the threshold. So we've streamlined it to not have those two layers, but just call it square footage of the building. So under the option A, we have if it's less than 4,000, it's reviewed administratively with, more like a building permit. If it's greater than 4,000 but less than 45,000, it requires a notice of public, so there is some public comment period in the beginning before an administrative decision is issued. And then anything larger than 45,000 is the Development Commission with a public hearing. Option B builds off of how our current code is, because there's also this, in addition to the site size, there's another layer which is high, prominent streets, basically. So the top part is the same as option A, but if you are on a prominent street that we included a map in your packet, that if you're less than 4,000, it still stays like a building permit. But if it's greater than 4,000, it automatically gets bumped up to a Development Commission. So the issue here is if you really don't front that street, but it's a 10,000 square foot building, then you get a different process. But if you're on the street, it's the same kind of an impact, it's a different process. So it can create this consistency of some property owners might say, well, that particular project went through a public hearing, but which was not exactly on fronting that street, we didn't have to. So we're posing the question to you all, what's the right threshold that should be reviewed administratively as opposed to going to the Development Commission? And this idea of the option A doesn't build off the idea that if certain streets get more scrutiny than other parts of the city. This map is included. I think it doesn't show I-90, but that's part of the list of the projects that would get the higher scrutiny. So the next thing that we posed a question about was the city projects, city road projects, parks projects, and other infrastructure. What's the appropriate level of land use review and permitting for the capital improvement projects? And we laid out our proposed options. The reason for treating these in a more comprehensive way is there's a lot of information that's built into these projects early on. There's community input received during the design phases. For them to get these on the city's capital improvement list, there's a whole process that goes into there. There's the project cost allocation that happens at the council level. So there's already all this public input that's received. And then when the permitting side comes in, there should be no surprises of, oh, you need to meet this because it's not meeting these permitting requirements. So what we're proposing, we've broken it down into city projects that are within existing right-of-way. And there are two flavors of those. One is just a repair and maintenance, repaving a street that's not expanding or anything. You don't need a land use approval. If you were putting a sewer pipe, which is over certain square footage, you might trigger SEPA. So those SEPA and shoreline thresholds are already baked in the state law, so they would still comply with those, but there wouldn't be an added review at the permitting stage. It would happen early in the process. The second option, flavor of the public projects within the city right-of-way are expansion of existing streets or infrastructure or providing new streets. In those things, again, public input and outreach happens early, and then when it comes time for permitting, that we would issue a consolidated review, which would ensure compliance with critical areas code. We would have the city go through a, why can't you avoid it? How can you minimize your impact? What is the mitigation if there is an unavoidable impact? If there's clearing and grubbing, so stormwater and temporary erosion control measures would be reviewed through a site work, but it would be a consolidated permit rather than multiple permits. And then the second type of public projects are not within the right-of-way, but on a separate parcel. So a new park or an expansion of an existing park. So repair and maintenance, no land use approval, SEPA and shoreline if you trigger any of those thresholds. An expansion or a new use, public input early on and consolidated level of review at the end. Separate SEPA and shoreline if those are triggered. So that's our proposal. The last thing, I think we've posed some policy questions for you, are related to vesting. Which code applies to projects at what time they apply for their applications? So in our state, vested rights doctrine has three specific things. A building permit allows vesting. So if a building permit comes in and it's deemed complete by the city, the rules in place at that time would apply to that. The review itself might take 2 years and the code might change, but they're applicable at the time they apply for the building permit. The second thing allowed under the state law is short subdivisions and, short plats and subdivisions. If they get the preliminary plat approval, that's the time that the rules in play would apply to them. Again, the idea here is if you get a preliminary plat and you've designed your infrastructure based on the codes in place, then you are allowed to finish your subdivision from that time. Or the state law allows a development agreement to vest when a lot of work is going to happen over a long period of time, and it's to protect interests for cities not being able to change codes often. The city can, however, choose to specify in their own code anything above and beyond what's allowed in the state law. So in your packet, we included information of what the cities are authorized to change. We can figure out what's deemed a complete application. That's going to be baked in in the city's codes. We may decide other applications besides subdivision, short plat, and building permits, like site development permits, those can vest a complete application. We can also say an explicit expiration date, whether it can be tied to an expiration permit, that protects things to not drag on for too long and the codes evolve over that period of time. If there's serious threat to public health and safety, the city can impose new regulations. That doesn't come into play a whole lot, but there are ability for the city to do that. Or if there's a major modification to the application that was submitted, and it changes completely and it's a huge change from what they tried to get the vesting in, the city can say you need to file a new application, and the rules in play at the time you file that application you'll be subject to those. So the options we've laid out for you to give policy direction or recommendation to council are that we follow what's allowed in the state law, and those are the three things that vest you, and we stick with that. Option 2 are you can expand the list from those 3 to other land use applications. And option 3 is you can have a time period of a limit, 6 months or whatever, from the time the code is applied. If you have this grace period of whatever time period, to be vested to the old code. So that pretty much concludes those 3 policy options or questions that we've laid out for you.
Great, thank you, Minnie. Do we have any clarifying questions for Minnie?
Thank you, Chair. Thanks, Minnie. So this is where I was going. And what I wanted to know, and I thought, and you almost answered my question, because what I'm having a hard time is comparing how is this different? So if we could just elaborate a little bit more, is the 45,000, for instance, a threshold in the old code? And is there also, because I'm having a hard time comparing them,
Sure.
between the 4,000 and the 45,000. Do you mind spending just another moment on what's the difference between the old one and this new proposal?
Yeah, so the old one has, for option one, or option two, option B is very similar to what's already in the code. The issue with the code is we have one standard in the central Issaquah, we have a slightly different thing outside of central Issaquah and those things. So for the most part, it aligns with your option two. That's in your packet from what's already there, but what option two doesn't have is another layer, which is 3 acres or below is administrative, 3 acres and more than 3 acres is development commission. So we've eliminated that. We've kept the thresholds the same under option B.
Thank you. And then the next question has to do with the definition of a building, and whether, just thinking about different applications of this threshold buildings projects, what other considerations are there?
So you're considering if there is not a building part. I don't know the definition. I haven't looked at our definition that's in the packet here. Usually
Okay, I guess one thing I'm thinking about is, imagine you had 2 buildings that were 40,000 square feet that, I don't know, shared some amenity or something, and they were part of a larger campus or something.
Okay, no, that's a good point. Yeah, I think we can clarify the language to say cumulatively. So if you had a lot of small ones, then they all added up to 45,000, then that would be the threshold that would apply. Individually, you may be a townhome project that has 4 different buildings, but cumulatively, it's 45,000 or more, but individually they're not, it would trigger.
Follow-up, so that's currently not there, but something that could be.
We can add
Yes,
the
thank you.
language to clarify, correct.
Minnie, I'm gonna start with question 1 that you had for us, and you gave us 2 different options. And the way that I read it, and Nina's fantastic comment kind of confirmed that the first option is kind of the status quo as we've had it. It's amended, but our thresholds are carried over.
The option B is more status quo, except for the 3-acre piece. Option 1, we took out the high visibility street option. So we made it consistent throughout the city. So you don't get a higher scrutiny if you're along these streets. Everyone has the same threshold. If you're 4,000, below 45, above 45.
Because this map is something we've already been using of this high
Correct.
visibility.
Yeah.
And so right now staff is recommending we move away from it. What I'm curious about if there's some other option that staff was exploring when they were going through these options. I think it's fair to say that the high visibility hasn't worked very well right now. So is there something else where you guys were looking at right now for this first question as another option to be presented?
We didn't consider a third option, but we can
Okay.
if there is, some desire to explore. I mean, out of the top of my head, I can say the third option might be you don't have the high priority streets, but you have more things, the threshold could be lower, 45,000 could be slightly lower.
I certainly thought about that.
Yeah,
So I was
yeah.
curious if
So-
staff did. Is that because of the direction from best practices of the administration, or is that direction of council?
I mean, there was probably some legislative history of why that threshold was chosen, so that's already existing in our code. So we weren't completely trying to get rid of that threshold either.
Okay.
Yeah.
Does anyone else want to stick on question 1? So then I'm gonna move on to question 2, and I feel like I've asked this question before, so I should know the answer, so you're gonna have to humor me. When we talk about the capital improvement projects, why is the city not held to the same standard?
City's held to a higher standard because you know, the fact that a project makes it into the capital improvement project list has to go through a whole robust public outreach. I mean, this year there was a whole, all the boards and commissions got to weigh in, what should make it, what shouldn't make it. So the city's committed to getting those feedback. The issue happens with the public projects is there's a lowest bid award. I mean, it has all these other scrutinies that happen. So you've gone through a public outreach process, you've taken the public input on what the design of this park should look like. At that time, the permitting and compliance with the city's code, you know, the design should already meet city's code. It shouldn't be
should.
at the tail end that you're having to, you would still get a permit and where the state law and impact to critical area and all of those things would be evaluated, but that's not the time to talk about what should the design, you know, what's the site development permit? What, is this access okay, and is this design of this building on this parkland okay? Those things have already occurred through public outreach and input, so it's a higher standard
They've
than a
already-
lower standard.
I agree, they've already occurred, but what I'm reading it is, then what would be the harm in continuing to have the same level of when we need to have a public meeting, the way that things are consolidated? In theory, then it should be smooth, but we've seen historically that there has been issues with capital improvement projects, even though it already has gotten all that feedback. So what I'm wondering is why we haven't built in kind of a safety valve to say we want to ensure by having this be the same process, the same way that we're consolidating permits, we still want to go through and have that same level of scrutiny. It should be much smoother because we've had all these other things in place. Why wouldn't we have that as?
Well, I think that there's a couple of reasons why. I mean, what's the outcome or the added value of that process, right? It's community's money that is being spent on redundant process. The process has already occurred in the beginning, so and just to have that unknown with, because it has to go through a whole bidding process and the bid documents and the lowest bid, and then it becomes time crunch, and suddenly the city can put in 50 conditions on 5 different permits, and then the way the contractors would charge the city would be any change order from one of those things. So it doesn't work effectively to divvy up public projects in that fashion on the permitting side because of all that work that has occurred up front.
Okay, thank you.
Any more questions for Minnie? All right, well, thank you, Minnie. So that is it for our presentations, and that is it for the commissioners' clarifying questions. I'd like to open the public hearing tonight at 7:18. Small text, 7:18 p.m. Has anyone signed up to speak and in person? And if so, please come to the podium and state your name before making your comments. We do ask that you keep your comments limited to 5 minutes or less. Anyone here to speak?
Can I ask a point of order?
Sure.
We appear to have 3 memorandums on the agenda. I've only heard the presentation of the first, what about the other 2? You've got general provisions, draft code, general provisions, and then memo investment. I haven't heard investment.
We just had it about 5 minutes ago. Yeah, it was rolled into Minnie, or, I'm sorry, was it Valerie's?
No,
Minnie's, yeah,
So you are ready for public hearing?
correct.
And Chair, we have 6 people who've provided notice that they would like to make comments at the hearing, a few in the room, and then we've had a few people queue up virtually. So I'd like to propose that we go through those who've indicated a desire to speak and then open it up, both in the room and virtually.
Okay.
If that works for you?
Mhm.
Okay. So the first person who signed up is a virtual attendee, Karen Eastby. Karen, in just a moment here, I will make you a panelist, so you should see the option to unmute and can choose to turn your video on.
Okay, I'm trying to start my video. Let's see. Second. that working? Let's see. Oh. Okay, great. Can you see me?
Yes.
Okay, great. So as you said, my name is Karen Eastby, and I'm here on behalf of the Master Builders Association of King and Snohomish counties. We are the largest home builders association in the United States with about 2,600 members. Thank you very much for the opportunity to provide comment on the proposed Title 18 updates. And my comments tonight relate to the vesting options being considered with the Title 18 update. So home builders depend on vested rights to successfully plan new communities on time and within budget, which are two factors critical to housing affordability and the availability of homes in our area. This is vitally important because at the moment, the Puget Sound region is facing a housing crisis, as we all know. According to the Puget Sound Regional Council estimates, over the next 30 years, we need to add about 1.8 million people. And according to estimates from the National Organization Up for Growth, we are already over 200,000 homes behind our anticipated growth. The housing shortage drives up the cost of home ownership, and for each $1,000 added to the cost of a newly built home in the state of Washington, approximately 2,200 families are priced out of the opportunity to own a home. In Issaquah, both Zillow and Redfin estimates show that the average cost of a home is over $1 million. So builders take on risk when they choose to start a project. Investing provides certainty and predictability for all parties that development rules won't change, which could otherwise jeopardize a project after initiation. Vesting is crucial to ensuring stability and fairness in the development process. And all of these things can contribute to a lower final cost of homes. So that said, the Master Builders Association doesn't support recommending option 1 as it's currently proposed. And that's the one that allows for vesting only as explicitly provided in state law and specified in active development agreements, because we think it will make it more difficult to vest projects going forward. We do, however, support option 2, which allows vesting at the time a completed application is submitted and also allows vesting with the other various land use applications. Providing builders with the reasonable ability to vest projects going forward, as provided in option 2, gives them certainty that they can finish their current projects and confirmation and predictability, the confirmation that they can predictably plan and build in Issaquah in the future, which is important as well, because you don't want to put people off of building if they're not sure that they can vest for future projects. However, we would request that if this is the route that you do choose to go, that you consider recommending also a delay to the effective date of the Title 18 update due to the significant COVID-related delays that many have faced over the past 2 or 3 years. And I think that was sort of part of option 3, but we would like the bulk of option 2 just also with a bit more time to get those applications in before these Title 18 updates come into effect. The other thing I'll just say quickly is we just given how the impact that this could have on Issaquah's growth going forward, it might be a good idea to take more community consultation on vesting options before making a recommendation. It's been limited, and it obviously includes the public hearing tonight, but it would serve the city to ensure that a breadth of viewpoints are heard on this issue. So I'll just say that. And regardless, we would encourage Issaquah to ensure that there's sufficient flexibility to vest projects going forward, no matter which option you choose. Doing so allows builders who want to plan projects in Issaquah to do so with confidence. I've also submitted more detailed written comments, which I encourage you to consider. Thank you all very much for your time and your consideration of our position. Thanks.
The next person who signed up to make comments is in the room, Hossein Karam.
Well, hello, Chair Voice, fellow commissioners, lovely staff. My name is Hossein Karam. I'm a developer doing a project in Issaquah, and I'm here to thank you for the opportunity to talk before you about the issue of vesting. I'm very grateful to the staff to have worked with me for so long. It's been almost 3 years, or a little over 3 years, and I just want to vote for and encourage you to consider option 3. I think all projects who have been, like mine, in this site development permit for the last 3 years, and by the way, Issaquah is a difficult municipality. It has a lot of challenges, our slopes and wetlands and streams that add beauty, but also create challenges for us developers too. It does take longer, and it takes things more complicated. Well, guess what? Combine that with the issue of COVID, we are still in a state of emergency in Washington State. We're talking about close to 3 years. 1.8 million people have gotten COVID in our state, and I'm sad to say about 14,000 people have died. There was a point in time that in the last 2 years, I was going through my permitting. I just didn't know if I'm going to be around next week or next month, or what would happen to my parents. So the permit wasn't that big of a deal. I mean, it was, but it wasn't, because we were so worried about life. So we have been through some very difficult times. And I cannot think of one thing in our economy that does not take longer or cost more because of COVID. It has really affected our lives. And I'd like you to consider that for all projects who have been in the site development permit in City of Issaquah, to grant them a 6 months extension to June 30th to be able to turn in their building permit. Actually, City of Seattle, so you know, City of Seattle did that. They extended for the IBC, which is International Building Code. Every 3 years, the International Building Code, IBC, is updated. And it's updated with advance notice. They do release information that these are the codes. That's kind of the Bible of construction and design. And for City of Seattle to come and delay IBC, which is the rule of the land in construction, for 6 months because of COVID, it means a lot. It means it has really affected every life, every aspect of our construction and design industry. And the way I found about the code change, I really wouldn't be here, honestly, if I had been known 20 months ago when this process started that there may be issue of vesting. I would hurry it up. I would do what I could, like I'm doing right now. And other developers, I'm sure, would do the same thing too. I got an email late May, and I'm lucky it didn't go to my junk mail. I caught it. It took me almost a week to figure out what this really means. So I really think we owe it to our developers to have gone through so much, to have invested hundreds of thousands and millions of their hard-earned cash and of their lives, to give them a little more respect and give them a little bit of time to get out of this thing. Now, I do think most of them probably will, but you just never know. A heart attack, an accident, something could really happen at the last minute to their consultants, to the staff here, we could have another pandemic, a war, something could break out and really could screw things up for anyone unexpectedly. So I think it's the right thing to do. The humane thing to do would be consider these challenges. For us, we're the people too. We're not any different. We provide housing, I provide housing and provide a service to the community. And I think we should be called a partner of the city in that respect. And by the way, the RCW 36.70A OTO talks about fairness and predictability in land use codes or laws in the cities. And I think those are very important words, predictability and fairness. And I'm sure that the city of Issaquah, lovely commissioners, lovely staff, they would consider those things. We're a small community here. And I think we don't want to create difference between us. If there's a hardship, the hardship is for anyone. And at the day's end, if somebody lost vesting, I don't think anybody will, probably nobody will, but if somebody did lost vesting and lost years of their life and millions of dollars invested.
Sir, you've reached your 5 minutes.
Yeah, I'm sorry. Who would benefit? Urge you to vote, consider it for a 6 months extension for a site development permit to June 30th. Thank you.
The next person signed up is also in the room, Mike Nykrim.
Yeah, hello, my name's Mike Nickram, and I'm from Bellevue, Washington. I come to you, a multi-generational family. My great-grandfather was able to homestead Gig Harbor after serving a few years under Ulysses S. Grant fighting Civil War and freeing Americans so they could have equal liberty as all the other Americans do. My grandfather developed most of the original university district, and I, with my degree in construction management in the early 70s, University of Washington architecture, I built homes all across the east side. First home in the city of Mercer Island, I had 6 inspections. Pulled a permit in the city of Bellevue here a few years ago. Those 6 inspections have now grown to 46 inspections. I built 50 homes up in Tallis, had a great time. I moved a lot of great families into that neighborhood. We have to have option 3 to move forward. Fortunately, I had the opportunity to be appointed to the City of Kirkland's Growth Management Commission. I co-authored the city's comp plan in 1995, and we called it our 2020 plan. That came and left a couple years ago, and if you want to see what we were trying to create in 1995 going downtown Kirkland, we hit it pretty well. When we build a home nowadays, we have to prepare plans so unlike that home I did on Mercer Island. I have to have a licensed architect, licensed structural engineer, licensed civil engineer, a licensed surveyor, licensed geotech, and a licensed landscape architect. It takes a long time to develop that process. When you change regulations, then we have to reset that whole process back into motion. It is really difficult to build homes in this area. I sit on the National Board of Directors of National Association of Home Builders. I am Seattle's representative of that. We sit around in forums 3 times a year. The other builders across the nation cannot believe what I tell them we deal with here in the state of Washington. Don't make it worse, all right? We've got the Growth Management Act. I support it. I helped co-author a comp plan to it. Staff's position on the option 1 is out of compliance with GMA. So GMA was consolidated to 13 goals. No one goal was more important than another goal. They were equal. 2 of the goals specifically read to property rights. The property rights landowner shall be protected from arbitrary and discriminatory actions. When you change regulations after a presentation and application has been made, that becomes arbitrary. Goal number 7, permits. States right here, state law. Applicants for both state and local government, which would be the city of Issaquah here, should be processed in a timely and fair manner to ensure predictability. We're simply asking for predictability. 6 months, even in that case, really isn't long enough. Hossein, I think, did a pretty good job of presenting just some of the few pitfalls that we've had to face over the past few years. So, folks, it's really hard to build a home. I raised the 5th generation here in the state, and I'm having a pretty hard time finding a home for one of my daughters here. Let's not make it worse. Let's follow state law. Let's go with option 3, do the best we can. I'm going to submit this document to staff. I want it entered in the record, the planning goals, and as highlighted of the Growth Management Act. Hey, thanks for listening, and I appreciate your time. I was there. I spent 4 years with the City of Kirkland's Planning Commission. I had endless meetings putting together a comp plan, but pretty proud of what we were able to accomplish. And it's been fun to be part of the Issaquah build out that you all are seeing today. Thanks. So, do you want this?
The next speaker is a virtual attendee, Beth Darenchang. Beth, in just a moment here, I'll move you up. Oh, goodness. Looks like Beth has dropped off. All right, so the next person who signed up is also a virtual attendee, Kyler Danielson. Kyler, I will make you a panelist now. You should see an option to unmute and can choose to turn your video on.
Okay. Hi. Thank you for the opportunity to comment today. My name is Kyler Danielson, and I'm a land use project manager for Lakeside Industries. Numerous pages of the agenda packet include definitions, but I didn't hear much in the staff presentation or commission questions about those. And upon our review of the proposed changes to the definitions in comparison to the previous code, we discovered that there are over 100 significant changes, additions, or deletions of definitions that were not clearly identified in the draft code document. The result is that the Planning Policy Commission, the City Council, and the general public cannot conduct a meaningful review of the collective proposed changes to the code. Many of the definition changes alter the impact of related substantive provisions, but we don't really have the ability to see them at the same time. We therefore request staff to provide a more comprehensive document that denotes all of the changes to the definitions and summarizes the potential impacts to the related substantive provisions. This would allow the planning policy commissions, the city council, and the public to have more fully understand the collective and the actual impact of those changes. Finally, the changes proposed today, besides the definitions, are expansive and cover many different issues, properties, and proposals. And I echo Connie's comments from earlier that the substance of this meeting is hefty and requires more than one meeting for the Planning Policy Commission and the general public to fully digest this content and its impacts on the city development future. So thanks for the opportunity and thanks for your time.
The next speaker is also a virtual attendee, Susie Burke. Susie, I'm making you a panelist now. You should see the option to unmute and can choose to turn your video on.
Hi there, I'm Susie Burke, Fremont Dock Company. I just want to echo what you've had some very good input here tonight. It's really important that people have time to digest any changes that are serious changes to vesting, to the application process. But before that, you folks really do have a hefty load. And I can't back up further. I mean, the idea of the definitions and reading this packet is a big, long process. And I give it to you with, I'm glad you're there to do it. But my input is, even after you agree on absolutely everything and you understand absolutely everything, the citizens need to be able to know and understand too. There are property owners that are not necessarily developers every day of their lives, and this is the one time that they need to be able to know and to know what they can do with property they already own. It is extremely important what you're dealing with, and I thank you for giving it the time, and thank you for letting me have a moment to speak.
The next speaker is also a virtual attendee, Susan Neville. Susan, in just a moment here, I will make you a panelist.
Hello?
We can hear you.
Oh, good. Okay. Hi, everybody. Good to be here. My name is Susan Neville. I'm a longtime Issaquah resident, and I really do hope I speak for the 37,000 residents in Issaquah. I would really like to go back to consolidating meetings, and I know that's what we started with today. I never had an idea that we would lose meetings rather than improve on them. And when I saw that we were definitely losing 1 to 2, and I don't know what the new review process is going to also have the implications on how many meetings will be canceled when those go into effect. So I'm really unclear. So I'm not walking away feeling like I've gotten any benefit from this change, and I'm not sure who this is benefiting. So I think that needs to be a little bit more clear. I totally agree with Susie Burke, who just spoke. Thank you so much. It's been a very tough going through all this. Is just a really long process, and there's a lot to digest. So I really appreciate her talking. And then lastly, I think the 45,000 threshold changes we're looking at for review, if I remember back, I know the Developmental Commission had said they were having a problem with this, and I really respect their judgment. And I think that's what came down last time. So I'm just going to leave it with that. Thank you, everyone, and have a good night.
We have one more person who's signed up to make comments. It's a virtual attendee, Connie Marsh. Connie, I have made you a panelist.
Would you like it?
Yeah.
Okay, so because I only have 5 minutes, I'm going to go fast. Again, the summary presentation provided by staff doesn't actually reflect the words in their draft code, and that concerns me because I don't know what we're going to get in the end. And without substantive review where we can actually spend time going through that, I agree with Kyler, we don't have enough time. And I basically agree with everything she said, so we're gonna +1 there. Along with Susan, the consolidation of the community meetings is unclear, especially when in the table presented in the draft code, it basically calls those meetings as optional. So it sounds like we're consolidating meetings, but we don't necessarily ever have to have any of them. And so no, big fat no on that. Let's go to administrative adjustment of standards. Now this is a change in expectation from what we were told. We were told for a long time that we were going to, in the end, have a chapter on deviations, so that we were not going to have a discussion of administrative adjustment of standards or deviations per chapter, so that we could actually understand what those might look like. And yet here we are at the end talking about administrative adjustment of standards per chapter without the benefit of doing them per chapter. So I resist that. One thing that looks okay is it looks like critical areas are not going to be able to be deviatable, but then there is one little beautiful word in that whole adjustment section, which is feasible. Things will be mitigated to the maximum extent feasible. We do not have a definition of feasible. And remember when we had that whole reasonable use sort of conversation? I think that's what it was. It must be super clear, because staff, not just the department head, is going to be able to be making these changes. And we have had a very hard time creating criteria narrow and solid enough to actually get the development that we want using administrative adjustment of standards. And it is unclear as to what the public peak into these adjustment of standards will be, the notification process, etc. So moving on to notifications, there's nothing talking about the active projects list or how there could be better ways to actually notify the public. For example, today we're just getting the Master Builders Association to these meetings. It seems to me there are a lot more people with a lot more land who would have been coming to these meetings all the time. So how come they didn't know? What would be a successful notification process? That seems to me to be a whole meeting, but we're doing everything all in one meeting all together at the end. So now the review for thresholds, that 45,000 square feet came specifically with the central Issaquah plan. And it was only allowed because then we required a significant website presence where people could see what all of the development would be in the specific central Issaquah area. What this is potentially doing is taking that 45,000 square feet and making that the way it is all over all of Issaquah. And while those streets and the streets we chose to raise the review level might not be perfect, at least it is something where people can see what new development may be impacting their lives and their businesses. And so if you go with the straight 45,000 square feet, you will not have that visibility and the notification. So we, even in, I think it was Urban Village Development Commission, they had a hard time not seeing the 3,000 square foot projects because they were finding that there were issues and problems when these narrow, tight areas were not being sufficiently reviewed. So I say that has to be much lower, or you have to create criteria or some method to only allow these large places to go where there won't be adjacent impact. Now, I don't think you're going to find that. Now we're going to go to the public. Now, it is
Connie,
absolutely.
this is Tisha.
Okay.
You've reached your 5 minutes.
You know what? The 5 minutes is impossible with a meeting like this.
Chair, no one else has signed up to make comments.
All right, well, thank you, everybody. One more time, is there anyone who'd like to make any public comments regarding the public hearing? Please.
Hey everybody, my name's Doug Bassler. I'm not a real estate guy. I'm not a developer. I'm a dad. I have 5 kids, all boys except for the 4 girls. And I got 2 of them married. I got 2 of my daughters married off. I got a couple more if anybody's interested. But they just recently bought a home here in Issaquah, and they're dinks, which is unfortunate for me because the grandkids from the other daughter are like way better. But this house was $1 million, and they're both working, and it's at the edge of what they can afford. And my daughter's like, I've spent my life savings, and it's back to top ramen and those types of things. And so just in the interest of fairness, I'm speaking in favor of option 3 to, we've all been through a lot over the last couple of years. And, these guys that are building our houses and trying to make our housing more affordable, I think we can give them 6 months and give them some time to recover just like the rest of us need. And I just in the interest of fairness, and I'll just leave you with this quote. H. Jackson Brown said, "Live so that when your children think of fairness, caring, and integrity, they think of you." Thank you.
I was trying to do the math too, but anyway, I want to say thank you to everyone who made public comments tonight. We have one more? All right.
Hello, my name is Frank Koram. I'm Hussein's partner and brother. We have been living in Western Washington for 44 years, and we have seen this place basically explode in population and opportunities, jobs, housing, and also the prices have skyrocketed in the last, especially 10, 15 years. And I'm definitely, because of these main reasons, plus the actual fact that we have gone to a once in 100 years pandemic, I really in support of the option number 3 for extension at least 6 months for the existing projects that are in the pipeline for this and other projects that we have. So that's my opinion and my decision.
All right, well, thank you.
Thank you very much.
Every time I ask, somebody else comes up, so. Well, I want to thank everybody for making public comments tonight in regards to our hearing. If there is no further comments, are we going to be? Are you speaking on the same? Are you again for option 3? Let's. All right. So thank you. I appreciate it. So we do have a large tally for option 3. Again, I want to thank everybody for participating tonight. It's great to hear voices from the community from different perspectives, and we appreciate it. With that, I'd like to close the public hearing at 7:50 p.m. Now it's time for our deliberations. So I'd like to propose that we go through this the way that we heard it, through presentations. And yeah, we'll begin there. Oh, I'm sorry,
Chair,
I'm sorry, I'm sorry.
I'd like to propose that we take a brief recess before we deliberate.
I think that's a great idea, Joy. Thank you. All right, well, thank you, everyone. Appreciate that quick 5-minute respite. So we are back and we are going to begin our deliberations over the presentations we've just heard. And we will start with your policy questions. So staff, if you could go ahead and please put those back up to jog our memory. All right, while I'm shuffling through my pages, does anyone want to make a comment about this particular policy question?
I'm going to start off by saying a big thank you to everybody who came and spoke with us tonight, and everybody who emailed comments to us throughout the week. We do read your emails and your comments, and they help tremendously, and so I want to thank everybody for their participation in this process, and to staff who's done a fantastic job. I myself contacted staff today because I was wanting some direction, and there was an immediate response, immediate help, and I want to say thank you to everybody involved, because this is a big lift, and we know that it's a big lift. I'm going to now actually address your question, which is to say that I want to start with a thank you. We, as well as many members of the community, have talked about our desire to keep DC involved. And this was a question that we had along the way, and I really want to acknowledge staff that they heard us and they built that in, and I really appreciate that. My next thing is a little less appreciative, and that is when we refer to the table on page 77 of 110, and that's table 18.204040-1, and we start looking at pre-application community meeting, optional, 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 except for preliminary plats is required. When we start seeing pre-decision open record public hearing, no, no, notice of decision, no for level 1 review. I have huge problems with that. I don't believe that this is the intent that we have asked for as we've been discussing how we want to redo Title 18. So I think it's very applicable when we're looking at the level of administrative review to say, is this correct when we're presented with it as is? So I currently do not agree with everything is presented. I love how staff gave us these pros and cons. I completely agree about the consistency issue for having this visibility street standard. I agree with staff's recommendation to do away with it. However, I would very much like to keep up a higher level of review. I think that it would be applicable to talk about how we have a different option besides 1 and 2, and we talk about a hybrid model. Because at the heart of this, what we're really trying to do is synchronize a lot of code throughout the city and be able to have a standard. Right now, I'm not seeing an option that works for us right now. I'll start off with that.
Thank you, Commissioner Lewis.
Yeah, I want to echo almost, I think, everything that was said. I want to extend my thanks as well to the public comment and to those who emailed. It's really helpful. I'm not a developer, and so to hear your perspective is really valuable, and I appreciate it. I also wondered about kind of some of the no's and the optionals on that table and why they're there and not required. I also want to kind of revisit my comment from before about whether that decision to kind of go from the 3 or 4 meetings to the 1 meeting was based on public feedback, and just acknowledge that I know we heard a little bit of public feedback that's not preferred. And so I think that there might be some way to think about that. And then lastly, I want to also echo Commissioner Lewis's comments, scared me, on the thresholds and looking at the examples here of like thinking about City Hall and the library, like 2 very prominent buildings, right? not having that more in-depth review, you know, if they were to be built today, feels a little crazy. And so I think like an option 3 that was kind of mentioned, where that threshold is lower. I don't know what that level is, because I think in theory 15,000 maybe that's low, but then again, thinking of like the prominence of that building, you know, I would want to see that go through a more in-depth review. And so I don't know if I have like something concrete on, you know, what the answer to that is, but in general would support a lower threshold, and maybe you know, something about like impact or prominence as a factor in that.
Commissioner Melgo?
Thank you. So +1 to both of you. Brilliant, ladies. Thank you. And also, but I get to say my own thank you to the staff and to the public. And I was thinking today how, gosh, you know, we always come in here, guns firing. You know, it's like you don't hear anything that we agree with you about that you've delivered. You know, you deliver hundreds of pages to us, and then we go straight for those 6 pages that we don't like. And so I wanted to make sure that you hear the omission of the things that we don't talk about. They're thinking, oh yeah, that's cool. Okay, that's cool. A lot of good work here, and really appreciate it. And you know, we're getting closer to coming together on these things. Now, I'm really glad to start with this question. Let me say, though, clearly, the public who came, public who showed up on screen, and those emails are helpful. I read them too. So thank you. Didn't want that to go without. So at the 45, not to repeat anything that these 2 commissioners have said, because they already said it so well, but to complement that, if we're taking a standard from central Issaquah, which is expected to be a denser developed area where larger projects with larger buildings would be, maybe in thinking in that context at 45,000 square feet would be great. But in the rest of the city, so many projects would go without the wisdom and review of the Development Commission. And looking back over my notes this week at the meetings that we had with the Development Commission, the just high value of that organization and the services that they provide, I would not be in favor of the way that this is set up now. Because it's not recognizing the difference between central Issaquah and the rest of the city, and I don't think it's recognizing the value that the Development Commission brings. So I am not in agree with this. I don't have another idea, and I think one of the reasons why I don't is, as Commissioner Lewis brought up, the complexity of the issue of just putting a square footage on it. I just brought it up the other day. People, I mean, with Director Dhaliwal, thank you. I was trying to think what your title was, and that you could come in with pieces and avoid the threshold. I think there needs to be just a little bit more consideration to fulfill the spirit, and I think this will be my closing comment on this, but I might need to say it again later. If you can't say that we've improved public awareness, then we haven't met the objective of the update. So that would be the sniff test. I don't think this does. Not sure what it does, but it's somewhere around there. Keep dialing in on it. Thank you.
All right, well, thank you, commissioners. So again, fantastic comments from my colleagues here. I think part of the problem is we have a collective trauma in this city of what happened prior to the moratorium. Everyone is concerned about what may or may not happen. It is the reason that triggered the moratorium in the first place. Myself, I mean, you guys should already know my answer when it comes to this. I like streamlined processes. I like efficiency. I do see the point that the Development Commission has been a fantastic review board. But again, I actually like some of the efficiency by going down to option 1. I believe option 2 even states that it makes it a little bit, not a little bit, makes it more complex. I think Issaquah needs to decide whether it wants to be a city that has development and is open to it, or continue to go with something that I've said here for a very long time, continue to have the reputation of being hostile. Again, I think there's areas where I could even agree with fudging the numbers, because again, it does seem pretty strange that something as large as a library, large as City Hall, wouldn't have that type of review. But in terms of being able to have some of this done administratively, I think that is an opportunity missed. So I am the outlier here, once again.
Thank you, Chair Voice. And I do want to agree with you with the spirit of, while we improve public awareness, we streamline and make it easier for us to get the great projects we want. I'm totally in agreement with you. And the other thing I missed commenting about is the visibility streets. I remember this coming up and approving it somehow. I don't know why I was involved in that, but it seemed like a good idea at the time. Now it just seems like it adds complexity and doesn't give us value. I think every street is a visible street. Every street matters to everybody in Issaquah. To say that these ones are more valuable than where these other folks live just doesn't feel right to me. So simplifying for two reasons. One, for the sake of making it easier to process the good projects that we would like to have. And number two, because it seems unfair to the other streets.
No, and I will say to Commissioner Milligan's point, who I think made it very well, I think, again, there's a little bit of collective trauma here about what happened about 6 or 7 years ago. I am not in favor of ugly buildings. If anyone, I'm probably the guy more worried about aesthetics than the other things. Thankfully, I have wonderful colleagues, wonderful staff, wonderful other boards and commissions that have all these overlays to make sure that our buildings are more greener or they're more efficient. They've got a lot of other wonderful things going on. So again, I am the last person. I think part of the reason some of this wave of code and things that happened prior, I think the staff's gonna have to tell me when the moratorium ended, but I think some of this stuff came into effect so hard because of it. There was so much work done during that period, and I'm not gonna single out some of the buildings that happened that might have triggered it, but yeah, again, to a point I've always made, I'm open to have my mind changed, and I think Commissioner Milligan made a few great points. And yes, every street in Issaquah is a visible street. There shouldn't be a difference between one or the other. But I'm going to be more in favor of streamlining processes to get us the building and the development that we so obviously need.
Well, I'm ready for a bumper sticker. Every street is visible in Issaquah. And so I think what we do have is a consensus to tell you that we agree with doing away with some of this, right? That we do want to streamline. That is a big part of the process of what we're doing for. I don't want to start putting out numbers of what I think is the appropriate. I do appreciate us switching to the idea of using our floor area ratio, right? Using FAR. So there's good stuff here, but what I would encourage staff is to come back to us with some more options and tell us, because right now it does feel like a big jump, right? And it feels like it's counterintuitive to the process of what we wanted to do, was to be putting more daylight, more accessibility on these projects.
That's good feedback. So at least there's consensus on not prioritizing some streets at the cost of other. So it should be uniformly and consistently applied. The scale of the development, we'll come back with some options. I think we've had some discussions about a 10,000 square foot versus a 20,000 square feet for SEPA thresholds. So we'll evaluate whether it makes sense. The reality of the existing code now is anything on those priority streets or gets bumped up to the Development Commission. So anything larger than 4,000 is going to the Development Commission. So if we land at something 10,000 or 20,000, but we'll lay out the options so you all can see the pros and cons and then pick one. But if you have any feedback for our analysis, let us know at any point. But we'll eliminate the high priority street option. We'll have some different options for the scale of the project that'll be administrative versus public hearing. Sounds good?
Does anyone have anything else to add to policy question 1? All right, I think we're ready to move on. Who has policy question? Yes, we're looking for a change in the slide. Oh, okay, there we go.
So I'm going to start by playing devil's advocate and say that I think that I would be able to be moved on this with greater presentation from the city. So to the points that were made by members of the public, that more information needs to be gone through on this. As we sit right now, I feel more hesitant, I will tell you, with the information that I've been given. I'm more towards type A, right, for repair and maintenance. And I don't know that that is necessarily based accurately. I think it's just on the information that I have, which is solely what's been given in my packet. So what, again, I would encourage on this particular discussion topic, which is hard because I know you're coming to us saying, help us move forward. And I almost want to come back to you with more questions of saying, what more can you give me to help you, right? I don't know that this is terribly helpful, but right now, my opinion of this, of what is appropriate, is to have a same level of scrutiny and to have a high level of review. I think that when we're doing repair and maintenance, obviously our state code will dictate it, but anything prior to that, having a level 1 review doesn't feel true to the spirit of what the community wants. So I would encourage staff to come back to us with more examples. I appreciate your answers to me, Minnie, very much, because it helps me understand where we want to be good stewards of taxpayer money. And that was a great example of something that I was like, well, why are we doing this, right? So again, if our chart looked a little bit different and we didn't have so many no's, so that I knew that when there is a level 1, there is still, right, a pre-application community meeting, even after we've had all these things, right? I can appreciate that we've already had all these different places for input, but I still don't think that should negate the opportunity for when we have the permit, we're beginning it to then have a community meeting, because in theory it should go pretty smoothly, right? We've already done all of our due diligence. We should be able to have a complete alignment to what is code, but we've seen in the past that that doesn't happen. So when level 1 review looks like this, it's hard for me to advocate for that. But that doesn't mean that I'm sitting here in a position saying, I absolutely don't think we should do that. I just think that I need a little bit more information to be able to feel better about it.
Thanks for this. Yeah, +1 on maintenance sounded just great when I got into the other two of expansion and new projects. The level of review did not seem adequate for a couple reasons. One is it's not only because it's public money, but it's a public project. And to have, Louis said earlier, a lower level of scrutiny than you might have with a private project, the partnership with the people, because it is the people's property that we're developing, I would think that there could be a higher level of review that would have felt more adequate to me. This just didn't seem adequate. That's the level of discomfort that I had at this. So something a little more would probably get me there.
Yeah, I want to start because I realized not intentionally in my last comments I didn't thank staff, and so I wanted to jump on the staff love bandwagon and thank staff as well. That was not intentional to leave you all out of that. Appreciate everything. Agree with the repair and maintenance making sense. I almost wonder with the expansion or new projects if there's also like a threshold thing there. Like for example, if you're just extending like a sidewalk from there to the end of the curb, but it's a new sidewalk, like does that need to be like a whole big thing? Like maybe not, but if it's expanding like a road by a lane, then that makes sense to have a more in-depth process of review. And so again, I am not very helpful in that I don't know what those thresholds are, but wonder if that's kind of an approach to find a happy middle somewhere in there.
Yeah, so, you want to think about it in a way of what we are trying, is it the public input is the issue, or is it, putting them through a review process in itself is one thing, but what are we evaluating it against? What criteria? So we have a site development permit with the criteria is written for, a private development on a private piece of property. So what is it that, in addition to the community input, which should occur earlier in the design process, because it's harder to change plans when they're fully baked and all that kind of stuff. So if that's already built into the process early on, what's the value added, but also what's the criteria it should be evaluated against. So I think that would be helpful information for us, because we can create the process, but the process in itself doesn't result in any different outcome. So that would be my
Yeah, so
ask,
just
yeah.
to kind of chime in, one of the things that I flagged in the text was that it occurs early during the design phase, and like just thinking of like the conversation we're having now, right? If there's option 1, option 2, option 3, you might get input on that, but then there might be like more like or different input once that is like choice is then made. So it was just I couldn't tell from here if it's just the one and done, or if there is like a subsequent, even before permitting, kind of opportunity for public comment.
Yeah, so, we can look at that. One option, I'm thinking out of the top of my head here, but we'll coordinate with our streets department and our parks department in terms of how, I think the comfort level of what that initial feedback looks like perhaps is important for you all to understand. I mean, they go out to these meetings, they have open houses, they, share what the plans are. So what that process looks like from a community input. But one option could be that if there is a parties of record established for the folks that engaged during that process, that we keep them apprised as the project moves forward. So we could build in sending a notice of application when this, whatever level we settle on, comes in. So they know that now this has moved on to the permitting stage, and here it's posted on the active project. We can build in some sort of process related to that, but it would be the consolidated permit. It would be one permit, not a site development permit, which doesn't quite blend in for this based on what the criteria is written for. Yeah.
All right, well, thank you. So I like staff too, so I'm just gonna say that out loud. But yes, I agree with number 1, and I do want to say something, is I don't feel like this was fleshed out enough. Having said that, I think having the input at the design stage is more than enough. I do. That is and whether we make that bigger, I don't know. That could be a question, whether we have multiple open houses, but during the design stage, before the bids come in, that's the critical part. To have and I want to say thank you to Minnie for explaining it so well, because again, that's not said here. Those points that you made are so pertinent, yet they weren't involved in our packet. So again, I'm here to be persuaded, and that's something that tugs at my heartstrings, because again, every time there's a change order, that just pushes out the projects farther and farther. It costs more money, and where the city really I would imagine where the public really wants to be involved in is with the design. So when I look at the new Festival Street that they've just put in, it looks beautiful, and I'm sure that probably came up over the pandemic when they strung up those lights. Well, let's make this a Festival Street in Front Street. So again, I think the critical part for having that type of discussion, which I do believe is completely necessary, is during the design stage before we start submitting bids. Because once we start submitting bids and then you have a change and then we go through a type of review process, then this thing becomes exponentially bigger and more costly. And again, those are things that they seem redundant and unnecessary.
Chair, you will be happy to know that this very commission worked on Festival Streets long before the pandemic, and the community spent a good chunk of time talking about it. So you should know that there was a great deal of wonderful conversation and implementing different designs, and we are very happy to see it beginning to unfold before our very eyes for our community. I will say that there is also an issue here that isn't just about community input on design. The city has not always been the greatest arbiter of being able to regulate themselves. And there have been times when projects have gone through that have not adhered to the very code that we have. So expecting us to police ourselves in the same way that we always have is a little bit of an issue. So there needs to be a few more built-in ways of saying that we will be held to the same standard and level of account. That doesn't mean that we necessarily need to send everything to a hearing examiner, right? Because we do want to be good financial stewards, but what we want to make sure is that we don't have things in our history where we've taken out heritage trees because it didn't fit with what somebody in a particular project thought was the right thing to do. Again, all on staff, right? So there needs to be a little bit more built in of saying, there's a different level of review, but these are the check boxes that we're going to make sure happen so that we're having continuity throughout as a good partner in the community.
I did not realize that that was something prior to my time that you guys had worked on. I thought that was honestly something, yeah, I was kind of wondering, how come I haven't seen this before? But I thought the inspiration actually came from the pandemic when we had the different eateries and streeteries outside, and then they strung up those beautiful lights. And by the way, this is off topic, the beautiful flower arrangements on Front Street, fantastic job. Love to see those a little earlier in the year, but fantastic job regardless. The street looks lovely.
So I would like to note, 2014, the downtown streetscape conceptual plan was adopted, and it's on the website if you'd like to see it, but it included the Alder Festival Street.
Interesting.
Yes.
Yeah, so far it looks fantastic. I'm excited to see it. All right. Any other comments as far as policy question number 1? Again. Minnie, do you have what you need?
Yeah, I think more of a point of order. So do you want us to take this feedback and come up with some way of closing the loop with the public comments that we received early? Or how would you like us to come back? I mean, is part of the final, or are there options you're asking us to come back with? Or I want to be clear that, I heard multiple kind of things, but I think what I heard was plus maintenance issues, pretty consensus on those. The new and enhanced things, we could persuade everyone with the same level of review, but some accountability for holding ourselves to the same standards that have been adopted. So we'll look at what that accountability looks like from a public review process.
Yeah, I think that it could be that both in our packet it's A and B, right? We could with a different presentation be able to see that B is in the best interest, but that would mean adjusting what level 1 is in a sense, right? Not actually changing the outcome of the director being the decision maker, right? But
having a public comment opportunity, so notification, not necessarily a public hearing, but it may be a notice required.
Yes, so I think that it doesn't necessarily need to be that this section changes, right? It could just be that that you don't give us options for B. It could just be that you still present it the same, but you're showing us how we're actually amending and changing the level 1 review for the city will include these steps.
Okay.
Right, so that's what I don't want to say that we
How
need to
we would
redo
implement
this. It's just
the-
that as presented right now, we definitely have an agreement on A.
Sounds good.
Yeah, I'll just say for me, Minnie, again, this was not the explanatory enough. It was your presentation that helped me get there. So, again, I'm here to work with a bunch of different people, staff, my colleagues. Again, my big thing is I'd like this type of whatever we come up with, whatever it looks like, it needs to happen prior to bids being commenced and things like that. I think if we try to do the review as it's continuing to move, as it's presented, the city ends up being in the losing position.
Thank you. I just want to thank you for the word accountability. That is where I was so unsure and unclear about what was uncomfortable about that. And Commissioner Lewis was bringing up that the public input isn't necessarily to improve the design or change things that have already been worked on, but it shines a light and makes accountability for those who are making decisions who could seem to the public and be public visibility creates accountability. That's what I think I'm looking forward to. I'm really glad you brought up the word.
Sounds good. Okay. I think we got what we needed.
before we jump into vesting, I do want to mention something. Half of our packet was definitions, which has not been touched on at all tonight. I will tell you that staff was great about discussing with me about the definitions section. And I will say, for anybody who also slogged through every word, realized I needed to break it up a little bit because it's easy to read without actually taking a critical eye to it. But knowing what I know about definitions and knowing that there are a variety of legal reasons and constraints about what we can change and why made me wonder how is the best use of our time in discussing definitions tonight. So what I will say is that from my perspective right now, I'm kind of putting a pin in it because what I'm looking for is the next time that we see definitions, I know it's going to be updated. I know that it's going to be richer. I know it's going to be better, and it's going to be ready for a little bit more feedback. So know that it's not something that has escaped us, and that we look forward to a very detailed discussion about definitions because it really does make an impact. It really is important, and though we haven't touched on it tonight, it is something that in the next draft I know we will enjoy.
Yeah, and since we're going to bring up definitions, I will second what Commissioner Lewis just had to say. I thought the public comment tonight about definitions was spot on. I did slog through that, made for some great reading. Again, I'm definitely not a dictionary. I'm not Merriam-Webster, so I'm usually trusting, but there were definitely some areas where it kept saying refer here, refer there. And again, I'm not going to be able to write the definitions. That's purely a very technical and legal thing, as Commissioner Lewis pointed out. But yes, it did seem like a lot of the packet, and to get no attention does not seem appropriate. All right, vesting. Heard a lot about vesting this evening. Would anyone like to go? I can go first. So first of all, I want to thank you to everybody who made a public comment tonight on this particular topic. Prior to what some people think, the letters and the emails that we received, we read them all. And it's very important that people understand that, because I think sometimes there is a misconception that because it's emailed, it doesn't have the same weight that a public comment in person might make. I actually happen to believe the opposite. I believe that me being able to read something and then reread something is actually much more fundamental, easier for me. When I hear it in public, of course I'm paying attention, but I only get one shot to hear it. And also trying to run the meeting as a chair, I can miss things. So again, I want people to understand that regardless whether you make them publicly or not, sending in the information, I believe I read at least 8, one from a lawyer, one from the MBA, and I won't continue to name names, but all of them are fantastically written. I read all of them. I read a couple of them twice just to make sure I understood the spirit of what they were saying. So again, please do not think that just because you weren't able to speak publicly that it does not count. That is part of the public process. Yeah, appreciate that. I'm gonna, also part of being up here is to represent the community, and I overwhelmingly heard people opt for option 3. Now here's the part that I'm gonna say that might break a few hearts, is the Planning Policy Commission only provides recommendations, and I am happy to provide the recommendation that I do full-heartedly agree with, especially during the pandemic, that there should be some built-in delay for people that have had their projects in permit over the course of the pandemic. The sad part is we are not the authority that can make it happen. All we can do is provide a recommendation. However, again, I do believe that when people have vested the time and energy to get these permits through, that it is important we acknowledge. Again, I'm here as a son of a contractor, not a developer. I've never put in a permit for a large project, but I do understand the time that it takes for contractors to push these things through. I'm going to go back a little bit to what I said earlier. There is, I believe, a little bit of a collective trauma in Issaquah from years ago, but I do believe that we have enough overlays and enough accountability in different places that I think, like I said, we need to give some latitude to the developers who want to come and build in Issaquah, because again, I work in a small industry, and I hear a lot of things, and again, I'm not gonna continue to repeat myself. I'd like Issaquah to be more welcoming to those type of developments. Again, we've had discussions as far as the missing middle, as far as not having any condos here, as far as not having enough certain type of housing. So all of these things are essential needs that we need in order to help house people that work here, so they can actually live and work here. And Issaquah could essentially use some of these things. So I am listening to the public comment that I heard tonight, that I heard through the written statements, and I am in favor of option 3.
Can I ask a question? Is that allowed?
Yeah.
Yeah, it is.
Go for it, Vice.
So, I have a question about how, if it's really option 1, option 2, or option 3, or if it's option 1 or option 2 plus option 3. Because option 3 reads to me as like a extension for things already in the pipeline, whereas option 1 or option 2 are like how vesting works going forward. So I just wanted clarification there.
Yeah, you can come up with option 4, that's a combination. We'll obviously review it with legal and everything else, so, yeah.
All right, so I'll vote, again, I think, I appreciate the public comment and the desire for that option 3. And then I'll leave it there. I won't make it more complicated by adding in an option 4.
For going down the line, I'm gonna say that the information that was presented to me by staff made me concur on option 1, because I don't have enough information to tell what various land use applications could be with option 2, right? What you presented me and what the information I was able to see was what state law allows. That looks good. When you tell me various land use applications, I get a little nervous, right? So right now I'm not in favor of option 2, but that could be because I'm, again, not informed properly, right? So I, at this point, would like to tell staff that I am uncomfortable with the recommendation of option 3, because I don't believe we're at that place yet. We've heard a lot of amazing comments from the public. I know we've all been personally affected economically, culturally, and there is a variance that needs to occur in a discussion from council if this is something they want to consider. At this point, council has not asked me to consider this. Staff bringing up this option 3 in terms of vesting as far as a moratorium, some sort of delay on the work that we're all doing on Title 18, makes me very uncomfortable. I think that we're working very hard on this because there's a reason for it. We need to update Title 18 as quickly as we can. That is why we're all working so hard. This is why we have an aggressive calendar, and the idea of us trying to push it out because of other unmitigating factors makes me uncomfortable. And frankly, I don't think we're there yet. We haven't seen draft 2. We don't know how our calendar is going to be impacted by the rate of which we're able to go through this. So I think this is a little early in the dialogue to be discussing option 3. So I'm going to be reserving my comments on option 3 until I think that we're at an appropriate time for it. At this time, I appreciate the staff is considering it. I think it's something we all need to be considering it, but I think we're too early in the process to be saying whether or not it's a good idea.
Man, now I have to go. Okay. I want to ask a question too, or 5 questions, because vesting, this is a huge topic. I'm tempted not to talk at all about it, but I think that I can contribute some reflections. One is I want to understand from you all, separate from the Title 18 update date, today, how does a project vest right now?
Yeah, so, we didn't want to have all of those discussions because the vesting statute still applies, right? But that's not the purview of the Planning and Policy Commission to make decisions on the projects that are currently being reviewed under the existing code. That is administration. We'll look at what the code is, we'll review it with legal and make decisions on that. So we want to kind of not get the issue to kind of go into what is happening with this project and what is the existing code, because it doesn't matter. What we're asking for recommendation is what should the new code be. That's why we didn't
Right,
kind of get
okay.
into the nitty-gritty.
Well, there are two things happening here, though, and this
Yeah.
is where I'm confused. In this triplet, that they don't seem to all go, there's something that's not like the other in here. It was brought up by earlier commissioners. There's, number 3 is saying that current applicants are having a problem vesting with the current code, and thus they want an extension so that they can stay with the current code rather than going with the Title 18
Yeah, so
update.
it's not just for, that would be for the projects that are under review, not necessarily under the existing code being vested or not so that's a separate conversation and a separate discussion. Under option 3 would apply to anyone, that would, depending on how it's worded and how it's structured, that would be the language in the code. It's allowed for the city to say, on this day of the adoption, we're giving a grace period of X number of days. So,
Okay, then, let me say that, again, I think 1, 2, and 3 are not, I can't put those all and say, hey, how can I pick between these 3? If I'm just talking about it, do I approve number 3 or not? 2 considerations come in my mind. Why aren't applications getting approved today under the current code? Why is this a problem? It's really hard for me to say, gee, I should give you an extension if I don't know that there's a problem or not. If there's not a problem, why would I give an extension? The other thing is, if we had 6 more months to work on this code, I'd take it. And then I'd just say, that's where we'll draw the line. That could be the extension. So I'm not inclined just on face value to say, hey, I'm going to adopt code, but everybody gets 6 months to catch up, a code that we've been working for 2 years doing. Unless you can tell me that there's been a problem with people getting their applications vested previous, but that's different. These things don't go together in my mind.
Yeah, so, anyone can apply for a complete building permit application and be vested. So, if you have a land use application that's, under the state statute, those 3 are your ways you get vesting. So people have that option. I mean, we're not adopting the code tomorrow. You have the months to apply for a building permit. So I don't know if that answers your question.
Yeah, I guess it does. I just don't know why people need an extension if they're able to get vested today. Everybody in the room, everybody who's ever written us, people who've been following us for the last 2 years, they've all been able to vest their permits. If that's the case, then I would not be inclined to give 6 months extension to applicants. I'd give 6 months extension to me to work better on better code.
Would the emergency have been the pandemic itself, having to meet virtually? I know that was brought up in one of the public comments. Basically, from March of 2020 till, summer of that year, everybody was getting their Zoom set up, things like that. So I don't know, is that the emergency?
I don't know that. I don't have the answer to that question. I'm just asking.
Yeah, in terms of the permit processing, we didn't shut down the permit processing, and that has continued throughout the pandemic. We're set up virtually, and it's actually, nobody's coming into the permit center because people like to just upload their stuff online. We were set up for online permitting way prior to the pandemic, so the transition for the permitting side wasn't significant there. There were some issues with payments and things like that, but those got drop off, things, and so, but now we're open, so if there's a fee for paying by a credit card, so for some folks that wanted to actually pay by check, had to mail it, and then we would get it. So, but that was only at the issuance of the permit that came into play. But now that the permit center is open, anyone can walk in and make the payment. So.
Well, I know for me, in our company, just like the supply chain problem, that's a complete pandemic problem. Maybe compounded by government, but regardless, it's a real problem. Things that used to take 4 weeks now take 12 to 16 weeks. So again, even though the online applications may have been, people could have been meeting with different business partners, different things like that, I think one of the public comments mentioned the different engineers they have to meet with. So again, I don't think it's a whole lot to ask, and it was very clear what the public itself wanted. So
Yeah,
that's
if you're
my
under
position.
construction, if you have a permit issued, we're not changing the rules that apply to you if you're under construction and supply chain had
Right,
an
this is
issue for
pre-
that. Yeah. Yeah. So, but, yeah.
Oh, one more thing. So to affirm something that Commissioner Lewis said, the word in the question is various. I think the word is various, and certain land use. Well, that's a good word, that's certain, but it doesn't tell me which ones they are. And so if the certain land use applications where these people are unable to get vested in the current code for some fault of the city, then certainly I'm backing them up every bit of the way. But if it's just to get another 6 months with old code that we've been trying to change for 2 years, I'm not really excited about that. But if the city is failing to get people vested, I'm concerned about that. And if that's the sentiment that I'm hearing in the public comments, that's a different topic. That's all I'm saying. I want to defend the people who are commenting. They seem to be expressing a frustration that maybe is not being discussed in this. Maybe this isn't the place where that frustration's coming from. I don't know. Just saying it.
In an ever-changing world, let's wait until we're actually through our final draft code, right? We are still in this middle of this process. I do not believe that this is the time for this conversation, and I don't even know right now if staff or the council is considering this. And so for me to consider advising on it is way premature. I don't see option 3 as being linked to options 1 and 2 at this time, and I would be happy to look at option 3 when asked to do so at a time when we've actually made it through Title 18.
I think you got a few different opinions there, so I don't think it's gonna get
think
any clearer
that's
for
fair.
you.
So we can take the recommendation from the Planning Policy Commission was split on this issue and capture your comments to Planning Commission without a consensus. So I think that we can move it forward that way.
Yeah,
Okay,
sounds good.
sounds good?
Thank you.
Yes, thank you. Do we have any other policy questions? Well, I know Commissioner Lewis brought up the definitions, again, +2 to that. That was a big chunk of our packet, and again, I do want to say thank you to everyone who did make public comments that we were able to read and hear. And yeah, we'll have some feedback for staff even when the meeting's over. Go ahead, Commissioner.
I'm trying to find it. Thank you, Chair Voice. I wanted to talk a little bit about variances and the approval criteria. I thought the feedback I wanted to give is I thought that it allowed for a little too much subjectivity because what we're trying to do is allow for variances, but to make it more predictable for the applicant and for the staff who approve them, or actually variances are approved by a hearing examiner, right? Yeah. And so, like, one of the phrases that caught my eye was "in harmony." Is something in harmony with something, and then you could get, anyway, that phrasing did not seem appropriate or enforceable or usable. And then the other thing is how I wanted to bring up for discussion, if anybody else noticed, how the approval of a variance could create precedent for neighboring properties, and that the neighboring properties could then get a variance because the earlier guy got a variance, but that can't be the only criteria why the neighboring property gets variance, because there's that little clause at the end. And where was this? And I thought this was odd how this kind of precedent-setting language is in the variance code, where also a variance can only apply to a special, unique circumstance. So anyway, there's just a little bit of contradictory or complex language in that part, and then the subjectivity and the approval criteria. Just wanted to bring those up for, if anybody had any other thoughts, or just to take that with you, see if it helps.
No, that's good feedback. Thank you. We'll take a look at that. Out of the top of my head, the neighboring properties may be, if everyone has a 5-foot setback and the code requires a 10-foot setback, does it make, does that, the street presence doesn't make sense, so maybe that's what it's getting at, but we'll take a look at the other subjective stuff. Definitely, we want to tighten that.
Yeah, I mean, reading through the entire packet, again, so much of it is procedural, so much of it, there's so much that involves, the planning department or the permit department. Again, there's legalese that, I don't sit in a planning and permitting department day to day. So yeah, there's some gimmicky things in there that definitely caught my eye as well. I just don't, I'm not able to tell what exactly is needed and necessary by the city, but there does seem to be a couple redundancies. There also seems to be some other thing that, again, I'll offer you some feedback by email, but, probably could go through the whole packet with you tonight about definitions, procedures, ask you 10, 15 different questions about why this is like that. I'm kind of leaning on staff, which I know does a fantastic job, but why certain procedures are there, and I'm sure we'll get there. But yeah, there are definitely some contradictory and some oddball stuff in there. Anybody else? All right, does anyone else have anything to deliberate as far as the public hearing this evening? Sure. Oh, I just meant as far as. Okay. All right, well, that takes care of the Planning Policy Commission's deliberations on the public hearing for Title 18, Bucket 6. Thank you, everybody. Now we're going to move to reports, and the reports from the City Council updates. So I'd like to ask staff if you could provide any, if you have any.
Sure. So, Title 18 is getting reviewed by Planning, Development, and Environment Committee. They've gone through Bucket 5, so the Bucket 6 will go to them on September 22nd. On September 7th, they asked us to come back to them with Bucket 4, which was building and design, had a lot of things that we were going to include in the final draft. They wanted to have those flushed out a little bit more. So we're doing a check-in with them on that topic on September 7th, and then taking your feedback that they'd asked us about the zero lot line and the street connectivity issue. So we'll brief them on your relook at that issue on September 7th. So that's what's happening with the planning. And the whiteboard, a list was shared with the committee, then it was shared with the full council. It is going to come to you all because we were waiting for the Bucket 6 to wrap up, and then we'll share that list with you. The urgency of sharing it with the council before Bucket 6 was done was because of the budget cycle. So there's some decisions had to be made in terms of which were the order of priority, what can be added in. So the committee said we're going to look at 3 criteria. Is it covered under the existing goals and outcomes? Is it covered under, the second one was other adopted plans, like strategic plan, mobility plan, and all that, and then the level of effort needed. So then we also shared with council of all the other things that the city long-range planning division is going to undertake in the next upcoming 2 years, which will come to you all is the periodic update of comprehensive plan. So that's a huge lift of every 8 years. The cities are required to do a complete look at comprehensive plan. So given all those things and the transit studies in the works and all that, so they picked 3 based on existing workload, those 3 criteria that they chose that they wanted us to work on in the next couple of years. Stream buffers, a more on-the-grounds assessment of those. The implementation of housing strategies plan, missing middle is one of them, but globally the adopted housing strategies plan implementation of those. And then parking. They felt that the parking stuff that we're doing with this update didn't fully capture the goals and outcomes that the council had laid out for this. So they wanted to at least get that done in the next couple of years. So that's where they've landed on the whiteboard. But we'll bring the entire whiteboard and for you to provide your input on. That's it for council updates. Our new planning manager has started. I don't know if Christian Guys is still online? Yes. He is, so we'd like to introduce him. If you can turn on your camera, Christian. We see a cloud. It's slowly moving.
I am here.
For some reason, we can't see you on. We can hear you. It's maybe a bandwidth issue. But Christian comes to us from City of Kirkland. You can see him. There he is. So I'll let him introduce himself. Hi, Christian. This is the Planning Policy Commission.
Hi, nice to meet you all. Yeah, my name is Christian Getz. I come from the city of Kirkland. I was there for about 15 years. Worked through many number of permit projects within the planning department. Worked on a lot of shoreline environment projects, capital improvement review. Very interested in the conversations tonight about how the city reviews city projects. I was very involved in those at the city within the planning department. So working with my counterparts over in capital projects, parks department, and I'm looking forward to working with everyone and seeing you all in person pretty soon.
Yeah, welcome.
Thanks.
All right, Minnie.
Yeah, and lastly, my turn to say thank you. I know we've been giving you so much, but this is a milestone. You went through 6 buckets, and we couldn't have done it without your diligence, asking us hard questions, keeping us accountable on what we give you, how we give you, and so I really appreciate all your hard work.
And we appreciate staff's hard work. So the feeling is mutual. Are there any other business or announcements from staff? Is there anything for the good of the order?
Except somebody has to remind me, what's the deadline for applications for Planning Policy Commission?
26th, I think. Tomorrow, I believe.
No, we had an extension.
I know, to the 26th.
So it's tomorrow? Well, that's,
Today's the 25th.
so tomorrow.
I think it's tomorrow.
Tomorrow, the 26th.
Okay, folks, tomorrow.
Just
And I'm not
looking.
talking to anybody in here, because we're already here. I'm talking to the audience and anybody who has a friend. We have so many wonderful public comments. We have people who contribute at so many different levels, yet I'd like to see more people sitting up here with us. You have one more day. It can be done. The application is like a resume. Just get your resume out if you're interested. I want to testify that this is such a fun group to work with, and the work is hard, yeah, but that's why it's fun. That's why we like it. It's significant, and it's a way to contribute to your city that's unlike any other.
We just confirmed, yes, the deadline is tomorrow.
Tomorrow. You
August
got it.
26th.
Do it. Apply. Thank you.
What a fantastic team. We all have one another's backs. So yes, +2, Commissioner Milligan. Any other thing? Any other comments? Nothing. So we're going to close tonight's meeting at 8:55 p.m. Thank you, everyone.